Good morning, everyone, and welcome to your employment update. My name is Jade Linton. I believe introductions have already been given, so I will start. In the interest of time, I think it's safe to say that it has been quite a 12 months in our lives so far. I'm sure you'd all agree, much less in employment law. The reality is I could speak for 40 days about employment law to you, but alas, I have 39 minutes. So due to these time constraints, this update will be a summary limited to 4 key cases that have had a significant impact on employment law, the employment law landscape over the past 12 months, but due to popular press may have slipped your attention. We will explore the principles behind these cases and the principles that you should take away from these cases and indeed their findings, which you can hopefully apply these to your internal processes, policies, and so on. I will then conclude this session with a look towards the future of employment law. The first case that we will look at is a case in the education sector, and that is the case of L and K. This case concerned a teacher, Mr. K, whose personal computer was found to have had a number of indecent images of children. Although Mr. K accepted that the computer was his, he denied that he had downloaded the images. Mr. K said the images must have been downloaded by his son or indeed his friends, but he was unable to identify who had in fact downloaded them. Due to the fact that Mr. K was charged with a criminal offence, he reported the matter to his employer. Mr. K was then informed that the criminal charges were not going to be pursued against him. Despite this, his employer, the school, L, invited Mr. K to a disciplinary meeting and Mr. K was dismissed. In reaching its decision, the school relied on the following reasons. Firstly, risk to reputation. L, the school, was concerned that its reputation could be significantly damaged if Mr. K was accused of this or indeed any similar offence in the future. The school were also worried that if it became known that Mr. K had been found to have had indecent images on his computer and they had not taken action to dismiss him, it would be reflected badly upon them. The second reason they relied on was their questions over Mr. K's innocence. The school believed that they could not, and I quote, exclude the possibility that Mr. K had actually committed the offence of downloading the images onto his computer. The school did, however, acknowledge that Mr. K had denied the offence and that he was not being prosecuted for it. The dismissal was found to be unfair. The letter inviting Mr. K to the meeting had alleged misconduct in relation to child images, not reputational damage. The allegation of reputational damage was therefore an entirely different allegation or charge, and as such required different evidence, and it was unfair to have found Mr. K guilty of having caused reputational damage when it had not been put to him as an allegation in the letter inviting him to the disciplinary matter. Furthermore, the tribunal found that the school was unable to show a reasonable belief based on the balance of probability, so more likely than not, that Mr. K was indeed responsible for the indecent images found on his computer. In this case, the school had only found that they could not exclude the possibility, which is entirely different. This is a very different finding to the fact that Mr. K had actually downloaded the indecent images. In terms of some takeaways that I would like you to note from this case, it is vital that employers are very clear about the reason for convening a disciplinary hearing. It is also important that in the event of disciplinary action being taken against an employee, the reason for the disciplinary action should dovetail with the allegations put to the employee in the invitation letter. An employer should make a finding of fact on what actually happened. Merely finding that there was a possibility that the employee may be guilty of the allegation is not good enough. Cases that on the face of it appear to be open and shut rarely are. It is important that employers keep an open mind, take advice on the options available to them. For example, in this case, it may have been possible, if framed correctly, for the employer to have dismissed Mr. K fairly for some other substantial reason. The next case involves the breaching of a COT3 agreement, that is a settlement agreement achieved via ACAS, and the enforcement of this agreement. This case was taken to the County Court and later to the High Court, and you will see a summary of the facts on your slides. In this case, Mr. Steels brought an employment tribunal claim and negotiated settlement through ACAS in the form of a COT3 agreement. Duchy agreed to pay Mr. Steels the sums of £15,500 in weekly instalments of £330 a week. In the agreement, there was a confidentiality clause saying that the parties agreed to treat the fact and the terms of the agreement as strictly confidential. After paying £2,960, Duchy stopped further instalments to Mr. Steels on the basis that they had discovered that he had breached the confidentiality clause by disclosing the fact and the amount of the settlement to a former colleague, breach of the agreement. The matter went to the County Court, and Mr. Steels issued proceedings there. And Duchy defended the proceedings by seeking a declaration that because of the breach of the confidentiality clause, the outstanding sums were no longer recoverable by Mr. Steels under contract law. The County Court judge, however, found that the disclosure of the fact and sum of the settlement agreement did not cause any commercial harm to Duchy. The County Court did accept, however, that it had created a risk that other disaffected employees might rely on the information as encouragement for bringing claims which lacked merit against Duchy in the hope that they would be paid off. They found that if it transpired that Duchy could bring a claim for damages by reference to the cost incurred in defending such proceedings, then there was merit in no longer paying the sums required under the agreement. It was not a clause that would automatically give the other party a right to bring its contractual obligation to an end, which is surprising. It was found that the breach did not go to the root of the contract and was not a repudiatory or fundamental breach, which meant that Duchy no longer had to pay the monies it had agreed to pay. It also found that Mr. Steele had not renounced the contract by his actions. The matter went to High Court. Duchy could only be successful if it could show that the term was a condition of the agreement. So the term of confidentiality was a fundamental condition of the agreement, and that breach of it was a repudiatory breach, which rendered the contract unenforceable. It did not state the confidentiality clause was a condition, which is intrinsically why this case failed. The court needed to decide whether, from the perspective of a reasonable person in the position of the innocent party, Mr. Steels had clearly shown an intention to abandon and altogether refuse to perform the contract. They found not as the breach was never likely to cause any commercial problems for Duchy, and the risk of copycat claims were very remote, especially given that the sum was not large. Some takeaways for you from this case. The parties can make specific provisions in the contract terms for what should happen if there is a breach of confidentiality. So, for example, if you disclose the form and the nature of this agreement, then there will be no obligation upon us to pay you the monies in the agreement. That is what was lacking from this COP3 agreement. The parties can also insist that the COP3 or settlement agreement specifies the relevant clause. In cases concerning larger amounts of money, there would of course be a greater opportunity to seek an injunction. So never just accept the settlement wording that you're provided by ACAS. Look at it from a critical eye to see whether if there was a breach of confidentiality or other material breach, that it would free you from your obligations to pay the sums in there. Our third case is the case of Shell and Tarmac. And this case relates to a personal injury at work and a vicarious liability claim. So where an employer could be held liable for the acts of its employees. Mr. Shell worked as a contractor for Tarmac. Tensions arose between contractors and those who were employed by Tarmac. One of Tarmac's employees caused 2 explosive pellets to explode close to Mr. Shell. The result of this was that Mr. Shell suffered a perforated eardrum, hearing loss, and tinnitus. Mr. Shell brought a negligence claim against Tarmac and also against Tarmac as being vicariously liable for the actions of its employee, Mr. Heath. Tarmac denied that the actions of its employee were within the course of his employment, referring to them as horseplay and as such not being part of an individual's employment. The county court agreed with Tarmac and the decision was appealed to the High Court. The High Court found that Tarmac was not negligent or vicariously liable for the actions of its employee. The court found it was asking too much for an employer to implement a health and safety policy which covered horseplay or practical jokes. Despite Mr. Shell making them aware that there had been rising tensions between contractors and employees, the court found that it was not a foreseeable risk. There was no foreseeable risk of injury, as tensions were not so serious as to suggest there was any impending threat of violence. Increased supervision to prevent horseplay or playing around, ill discipline or malice was not a reasonable step to expect the employer to have identified in this case. So very interesting there. And this case really shows the limits. It shows that this case has its limits in terms of vicarious liability. The workplace provided an opportunity to carry out the prank, but yet it was found not to be within the employee's work activities, and as such, Tarmac were not held liable. Moving on to our fourth and final case, Ferguson and Asset Management Limited. Now, this case is about 2P and employees who had changed their terms and conditions in favour shortly before the transfer. In this case, the claimants were company directors. 2 of the employees were employed by Lancer, and the other 2 were employed by personal service companies, and supplied their services to Lancer. They combined, the four of them managed one estate worth about £5 billion. The estate owners gave 12 months' notice of termination of the management contract, and Astria Asset Management were contracted to take over the running of the estate. So the work was going to pass to a new provider. Before the transfer, the claimants decided to update their contracts of employment and undertake a review of their own terms, which included giving themselves an annual bonus of 50% of their salary, a termination payment based on length of service, and an increase to their notice period. An employment judge found the pre-transfer variations were void when considering that it was an abuse of the EU law principle. Now, this slide is purely for your reference purposes so that you can understand the legislation behind it. For the sake of time, I won't expand, but do please read it because it gives some merit and understanding to the principle that I'm getting across. So we have employees that materially change their contracts in the hope that the incoming employer would be bound by these revisions. The parties accepted that the abuse principle was not properly relevant to the interpretation of the regulations, and the issue of abuse and interpretation needs to be considered separately. The claimants argued that the proper interpretation of variations must mean adverse changes as opposed to advantageous changes which they made. The relevant purpose of the law in this regard was to safeguard employees' rights, which involved the prevention of something negative happening to their contracts. They believed that the regulation should be interpreted to cover all variations, whether or not they were adverse to the employee. It was found that there are two elements that characterize abusive practices when it comes to amending and varying contracts, and they're interesting to note. The first being a combination of objective circumstances in which, despite formal observance of the conditions laid down by the EU rules, the purpose of those rules had not been achieved. The second is more of a subjective element, consisting of the intention to obtain an advantage from the rules by artificially creating the conditions laid down for obtaining it. They found that these elements were satisfied. The purpose of the EU rules, safeguarding the rights of employees, had not been achieved, and the purpose was to substantially, significantly even, improve the rights of the claimants. The claimants' intentions were to obtain an improper advantage by artificially obtaining a contractual variation to their employment contract in contemplation of the transfer. So a word of caution for you when it comes to changing contractual terms on the eve of a transfer, so to speak. You can see there that the law is very careful as it seeks to ensure a fair balance between the interests of the transferring employees and those on the other side, that being the interests of the transferee. This case was indeed very extreme, and it may be different where employees and the employer agree on the changes. In any case, where there is an agreed change in practice between the transferor and the transferee, this is less likely to lead to dispute. So at this time, we will have a quick look at what is on the horizon. And I say this with a disclaimer that the way this year is going, what I am about to predict may be subject to change. But as of today, these are some of my predictions in terms of things to have on your radar, perhaps to discuss with your policy teams as we go into 2021 and beyond. Starting with Brexit. So it seems to me likely that the government will bring about a number of employment law changes in the medium term, at least, as a result of Brexit. The rhetoric from the government is that this won't be the case, but I have my suspicions because they will want to show businesses that the country, our country, is open for business. And having employer-friendly legislation could be seen as an advantage of having your business in the UK. In particular, changes to 2P seem to me likely to be made given the historic complexities and difficulties that this regime poses to employers and indeed employees alike. Conversely, I wouldn't expect any significant changes to be made to discrimination law. In relation to gender pay reporting, in view of the COVID-19 crisis, the Government Equalities Office and the Equality and Human Rights Commission have, as you probably know, suspended enforcement of the gender pay gap reporting deadlines for the 2019-2020 reporting year. As you may be aware, gender pay gap reports would otherwise have been due from public sector bodies by the 30th of March and from large private sector employers by the 4th of April this year. The majority of employers would have gathered the relevant data by the time the announcement was made, with many having already reported, I've been told. To date, around 5,900 employers have indeed published their gender pay gap data for the 2019-2020 year on the government website, compared to 10,840 the previous year. Others may have chosen to run the calculations for internal purposes, which I think is noble and welcome, without reporting externally. This, of course, allows them to track changes against previous years and adapt their action plans if appropriate. Amid predictions that the economic downturn will indeed impact vulnerable and disadvantaged groups the hardest, think particularly our younger employees, disabled employees, and those from minority ethnic backgrounds, employers with a sound narrative around their gender pay gap should consider publishing their data voluntarily, or at least comparing it against last year's data with a view to making change. It is not clear whether gender pay gap reporting enforcement will be suspended again for 2020-21, but eligible employers should assume that for now it will not be and ensure that the relevant data is available. Setting aside the fact that many will not have reported for 2019-2020, leaving a gap in the long-term narrative, one key issue for next year's report will, of course, be the impact of furlough. And allow me to explain why. The regulations require the gender pay gap to be calculated by reference to full pay relevant employees. So this excludes any employee who is, during the relevant pay period, being paid at a reduced rate or nil as a result of being on leave. Leave is stated to include annual leave, various types of family leave, sick leave, and special leave. But this is not stated to be an exhaustive list. So the question is, will furlough leave be treated as leave too? And you'll see as we've gone from the expected 3 to 6 months into 9 months, this will have a significant impact on figures. And it's something to bear in mind. Some final changes now as I wrap up and leave some time for questions. Changes to the ACAS conciliation procedure. On the 16th of September this year, new regulations to amend the Employment Tribunal rules were laid before Parliament. The regulations alter early conciliation procedure with the view to reducing the bureaucracy and increase the tribunal's capacity
Hi everyone, just to let you know, we're just experiencing some technical issues and we'll get back on shortly. Thank you.
We seem to have had a technical issue there. Could somebody please let me know if I'm still being heard?
Yes, all good to go now, I think. Thank you.
Thank you, Ella. Apologies, everyone. I will continue from where we left off. So the key points regarding changes to the ACAS conciliation procedure are that the conciliator will now be able to contact parties in order to correct errors on the early conciliation form at any point during the early conciliation period. Also, there will be an increase to the length of the early conciliation period to 6 weeks from the current 1 calendar month. However, there will no longer be an inability to extend that period of negotiation known as the early conciliation period by 14 days. So the regulations will remove any reference to an extension to the period. This will be very helpful for parties and hopefully result in a more seamless transaction or negotiation period. Off-payroll working, that's gone quite quiet now. By way of background, on the 7th of February this year, the HMRC and the HM Treasury announced a change to how the extension of the off-payroll working rules to the private sector will apply when they took effect on the 6th of April 2020. Addressing concerns raised by businesses, the extension will only apply to services provided on or after the 6th of April 2020. And the HMRC has updated its employment status manual to reflect this change. The Chief Secretary to the Treasury also announced during the debates on the spring 2020 budget resolutions that the extension to the private sector of the off-payroll working rules would be delayed until the 6th of April 2021. This postponement is in response to the ongoing spread of the coronavirus disease and was stated to be a deferral, not a cancellation, with the government remaining committed to reintroducing the policy. So do please keep that on your radar. On the 17th of September, the HMRC published updates to its employment status manual, dealing with the extension of off-payroll working rules for the private sector from the 6th of April 2021. Now I conclude with a topic which is not on the slides, and that's following the Chancellor's announcement yesterday. The controversial topic, of course, of the public sector pay freeze, the 7.1 billion National Home Building Fund, and a restart programme plan for jobs. Now, it goes without saying, really, that this is likely to cause a lack of morale, low morale, lack of motivation And of course, the impact this will have on staff and their well-being is being seen now and remains to be seen as we continue to fight our way through this. I'd urge employers to have employee well-being at the very forefront of their minds, even if you're looking at it in purely commercial terms. Lack of well-being, sick leave, lost working days, impact on work being carried out. We should have that in the forefront of our minds now, and especially into the new year. Engagement that brings value outside of monetary terms should be something we should be looking at. Also, consultation, reviewing your contractual terms to make sure the pay freeze does not invalidate or place you in a difficult situation as far as that's concerned. I do apologise for the technical glitch. I have around 5 minutes left for any questions at this time. Failing that, my contact details are here. I'd be more than happy to speak to anyone who has any questions about the update that I've just given. Okay, I haven't had any questions, so I'd like to thank everybody for your engagement. We're finishing a little early.
Hi Jade, sorry, just to let you know, we have got some questions coming on the channel. If you look down on the left-hand side, the little with the question mark, I don't know if you can see them.
Bear with me, I'll have a look.
If not, I can always read them out for you.
Oh, great. Okay, let's see how many of these I can come through. Some really good questions. Okay, so I'll start with the first one. Do you think we will see the ethnicity pay progress to being a legal reporting requirement? Yes, I do. I do certainly think we will see that on the horizon. I have some queries around that whole ethnicity piece. It's problematic, I believe, in terms of getting a full and honest picture when you put everyone who is not from the default white British group into a homogenous group and collate data from that. If you're not looking at, if we use BAME as an example, if you're seeking to get data about pay gaps from that group, you may be artificially inflating the reality of the situation by looking at ethnicity as a whole without breaking that group further. So I do think that it's problematic and there are a few things to be ironed out there, but I definitely foresee ethnicity pay reporting on the horizon. Maybe not next year as we hoped we will see in view of the pandemic, but it's definitely something that I see coming. Okay. Jade, I think most educational institutions would be concerned by the first case example, and the issue seemed to be very much around how the allegations were framed. Absolutely. If any of us found ourselves in this position, how might you suggest allegations being framed? Well, I'd start by making sure that you're clear on what the allegations are. So you're absolutely right. I think this whole matter could have been resolved by a reframing of the allegations themselves. You often see employers rely on this whole reputational damage. Is that a charge, or are you saying that it happened? If you're saying that it's a charge, then you need to find evidence of reputational damage, not that it's just a risk of reputational damage. You can see there already the need to be very careful with your wording. If you're simply saying that there was a risk of reputational damage, then is that sufficient to merit immediate dismissal when you cannot evidence that there has actually been reputational damage? And that's where I think this case failed. It was relying on what could have happened, what could have been, may be the case, without any evidence around it. And they failed to form a belief a reasonable belief, which is the standard required for employment law, about whether Mr. K had downloaded the images onto his computer in the first place. I do think under those circumstances, even had it had dismissed Mr. K for some other substantial reason, as opposed to gross misconduct summary dismissal, they may well have avoided a finding of gross misconduct. So I'd always recommend your invitation letters are reviewed and assessed by your HR personnel, your in-house counsel, or a solicitor, especially where dismissal is likely to have an impact on that individual working in their chosen industry. It's well worth getting expert advice to make sure that the charges are framed correctly. Thank you, Graham, for that question. I think I've got time for just one more. Are there specific employment law risks that may be heightened in the university's response to the pandemic? Indeed, I would not be surprised if we don't see claims relating to duty of care, sick leave, so on, in terms of exposing staff and colleagues to risk in the wake of the responses by various universities to the pandemic. In terms, what has been very tricky is this whole you must work from home where you can, or even just their exposure to students and the pandemic and so on. I expect we'll see a number of claims ranging from constructive unfair dismissal, notoriously difficult to bring, even, heaven forbid, anybody who has been impacted by the COVID outbreak who works at a university, then you've got your personal injury complaints there off the back of that, duty of care and such like. I would encourage universities to really go back, see where refinements can be made to their policies, where they can justify their rationale for requiring staff to be on site and so on. Even if it's convening meetings, having a paper trail which explains your rationale, your justification, your consultation and so on with staff, because you're going to be relying on that in evidence in the event of a claim. I believe my time is up, so thank you. For those questions that I was unable to get through, my contact details are on the slide. I welcome those individuals who I was unable to respond to contact me directly. I'd be more than happy to go through my responses with them. Thank you very much, everyone. Thank you for your time.